The Supreme Court has recently struck down the Electoral Bond scheme just ahead of the 2024 Lok Sabha elections. This scheme, introduced by the Narendra Modi government in 2018, aimed to bring out transparency in political funding. However, a five-judge constitution bench led by Chief Justice D.Y. Chandrachud delivered a unanimous verdict declaring the electoral bonds unconstitutional. So in this video, let us try to understand what the Supreme Court has to say. What are the constitutional violations that the Supreme Court has mentioned? What are the invalidations? And what is the history and the detailed analysis of these electoral bonds? So stay tuned with us until the video ends. And don't forget to subscribe to News Hamster if you haven't already for more such explainers and videos. The Supreme Court, in a dual and unanimous judgment, pronounced that the electoral bond scheme violates the fundamental right to freedom of speech and expression under Article 19, Clause 1, Subclause A of the Indian Constitution. Chief Justice Chandrachud emphasized that curbing black money should not come at the expense of compromising citizens' right to information. The court asserted that the right to privacy under Article 21 extends to political privacy and affiliation, emphasizing that need to protect this aspect of citizens' fundamental right. Not stopping at the electoral bond scheme, the court invalidated amendments made to various laws, including the Representation of People's Act of 1951 and several income tax laws. This move underscores the court's commitment to upholding constitutional principles and ensuring the legality of all aspects related to political funding in India. The Supreme Court took a significant step by directing the State Bank of India, or SBI, to disclose the names of contributors of this 6-year-old scheme. Additionally, the court ordered the halting of electoral bond issuance and mandated submission of details of bonds purchased since April 12, 2019 to the Election Commission of India. Now, this data will further be published in the website of the Election Commission. This push for transparency aims to shed light on the financial backers of political parties, particularly corporate contributors deemed essential for maintaining a fair democratic process. The court ruled that information about corporate contributions through electoral bonds must be disclosed, as these donations often involve quid pro quo arrangements. The court also declared amendments in the Companies Act allowing unlimited political contributions by companies as arbitrary and unconstitutional in nature. Let's go back to 2018, when the electoral bond scheme was introduced, which served as an alternative to conventional cash donations to political parties. The primary goal, as emphasized by the Modi government or the NDA government, is to enhance transparency in political funding. Nevertheless, the critics contended that the scheme's confidential nature may breed corruption and create an uneven playing field among the political entities in India. The State Bank of India issues these bonds in denominations of rupees 1,000, rupees 10,000, rupees 1 lakh, 10 lakh, and even 1 crore. These bonds are payable to the bearer on demand. These are interest-free and can be purchased by Indian citizens or entities established in India. They may be bought individually or jointly with others and remain valid for 15 calendar days from the date of issue. Political parties eligible to receive electoral bonds are those registered under Section 29 of the Representation of People's Act of 1951, having secured not less than 1% of the votes polled in the last general election to the House of People or the Legislative Assembly. To ensure transparency, political parties must disclose their bank account details with the Election Commission of India. Donations are facilitated through banking channels, and political parties are mandated to provide explanations regarding the utilization of the funds received. Critics of the electoral bond scheme argue that it contradicts its core objective, promoting transparency in electoral funding. The anonymity provided by the bonds is seen as benefiting the broader public and opposition parties, while the government, through the SBI, could potentially identify and influence the funding sources. This opens avenues for potential extortion and victimization of companies, creating an unfair advantage for the ruling party. Amendments to the Finance Act in 2017 exempted political parties from disclosing donations received through electoral bonds, denying voters crucial information about contributions. This scheme's acceptance of unlimited corporate donations, including anonymous financing from Indian and foreign companies with 100% tax exemption, raises concerns about its impact on Indian democracy. The Supreme Court, emphasizing the right to know in the electoral context, faced challenges against amendments claiming unconstitutionality and violation of fundamental rights. The electoral bonds, offering anonymity to donors but not to the government, pose a threat to free and fair election as a concept that India has been following. The government's access to donor details through the SBI enables potential manipulation of information to influence election outcomes. The removal of pre-existing limits on political donations under the scheme further fuels concerns about crony capitalism, allowing well-resourced corporations to shape electoral outcomes. So what are your thoughts on this latest judgment by the Supreme Court? Does it make sense, or did electoral bonds actually promote transparency? Write us in the comment section. Thanks for watching. Don't forget to subscribe to News Hamster.